company law. Today we have to know what is the nature of the company. So to understand the nature of the company, we are having a very important case that is known as the Salomon versus Salomon, and another case known as the Lee versus Lee. Actually, the company is an association, no doubt, but company is a separate legal entity. There is no ownership of the members, or there is no ownership of the shareholders. Shareholders of the company are not the owner of the company, but they are the shareholder only. But the company is itself a owner. And when the company is itself a owner, it means the full sovereignty over the company is to the company itself. That is why the company can purchase the property with the name of the company, or company may sell out the property. But the company does these work through their directors. The greatest example of this type is Salomon versus Salomon. Salomon versus Salomon is the case where the role of the directors, role of the shareholders has to be decided with the company. What was it? It is a judgment of the 1895 to 1899. It's All India Reporter, Salomon and Salomon Company. What was it? Actually, Salomon was a shoemaker, shoe manufacturer, and Solomon's company was in the nice position, Salomon was in the nice position, and he had surplus property or surplus than the liabilities. So right now Salomon was created a company with the name of Salomon and Salomon, or Salomon and Company. He was created this company and make a 7 subscribers, himself 1, his wife 2, his 4 sons and his daughter. So these 4 was the subscriber, and he formed a board of director where he was the managing director and his 2 sons was the remaining director. Now Salomon sold out the company to any other person. Means company was sold out through the board of directors to the any other person. When the company was sold to any other person by the 40,000 sterling pound, 40,000 sterling pound. When it was sold out for the 40,000 sterling pound, he was the shareholder in this company also, where he was acquired 10,000 sterling pounds or debentures of 10,000, 20,000 shares of 1 sterling pound value. 20,000 sterling pounds, 20,000 shares means 20,000 sterling pounds, value of the 20,000 sterling pounds, and 10,000 debentures. So now he was sold out the company by 40,000 sterling pound, and he himself had 30,000 sterling pounds. So the company was transferred to any other person. Now Salomon was claimed his own debentures, his own shares he want to cash out from the company. Now the owners of the company, new shareholders of the company, is claiming that Salomon does some cheating with me. How? They claimed that Salomon was established the company and Salomon have their own shares in the company. Now he was sold out. How the debentures can be cashed out from the company now? If company will pay all the value of the debentures or all the face value of the shares, then how the company will survive? Because the company was in the surplus position in the liabilities, but now he was acquired some debentures and he want to get the value of the debentures. The matter was gone to the court, where the assets of the company was valued 6,000 sterling pound, liabilities to the Salomon in the form of 10,000 sterling pounds, and unsecured creditors 7,000. So the total assets of the company was 6,000 sterling pound, and now the liabilities of the company is 17,000 sterling pound. Company was gone in liquidation. When the company was gone in liquidation, it was claimed that Solomon himself was the owner of the company. And when the Solomon was himself the owner of the company, that is why whatever the debenture acquired with the Solomon is not correct. The remaining creditor is claiming that Solomon itself was the director of the company and he was the shareholder of the company, and he himself created the company. He was evolved his property in the company and now created the debentures in his own name. That is why the Solomon must not be able to claim the money, claim the debentures from the company. Honorable court was decided here. Solomon is the separate legal entity. Solomon is the shareholder only. Solomon had the debentures of the companies, but company is itself a legal entity. That is why there is no connection of the ownership of the company with the Solomon. It is right, it's very well that the Solomon was created the company, he was the promoter of the company, he was the managing director of the company, his sons was the remaining director of the company, and the remaining shareholders was his wife and remaining sons. But we can't say that the Solomon was the owner of that company, because company is separate legal entity, and when the company is a separate legal entity, then company has to pay the debentures to the Salomon, and Salomon is entitled to encash the debentures, and remaining creditors of 7,000 sterling pound is also entitled to get their money. Now the company was gone in the liquidation, then whatever the shares, whatever the percentage acquired from the assets, Salomon is entitled to get it. Means the remaining creditors who is claiming that 7,000 sterling pounds is from me as a dates over the company, and company's value right now with the assets is 6,000 sterling pounds. So 6,000 must be divided or must be paid to the remaining creditors of the company, but not to the Solomon. Court had in this matter that no, Solomon is entitled to get their percentage share in the company, and that must be paid first. Then the shareholders can acquire. So the debenture holder and the remaining creditor must have to, the Solomon has right to acquire the money from the company. There is a distinction of so many types of companies. What type of distinction in the association? Like partnership firm is the association. Society is an association. Non-profitable companies are the association. Some private associations is also here, but the company is not a such type of association where the partners is the owner in the partnership firm. Partners are the owner in the partnership firm, but in case of company, company is a separate legal entity and company is itself an owner. If the company is itself an owner, then the Solomon, the venture of the Solomon is the dates over the company. So the company has to pay, because company is a different thing and Solomon is a different thing. It is possible that the Solomon was the managing director. It is possible that the Solomon was the promoter of the company. It is possible that all the members of the family are the directors of the company or the investors in the company. But the incorporation is a separate legal entity. That is why there is no connection between the Salomon, and Salomon cannot be treated as an owner of the company. Salomon can be treated as the debenture holder, and Salomon has to acquire the money from the company like any other creditors to the company as a debenture holder. See, he is saying that the Solomon having 20,000 shares in the company, and remaining shares are to the family of the Salomon. That is why the Salomon cannot claim the debentures over the company, because he himself is the shareholder and his family is the shareholder. That is why the another creditors is saying that we are entitled to get the dates first. The court is saying here that Salomon, even Salomon is the major shareholder, even the family of the Salomon is the shareholder, but the company does not mean that the shareholder is the owner. Shareholders are not the owner of the company anyhow. Company itself is separate legal entity. Company is entitled to purchase the property. Company is entitled to gain the property. Company is entitled to get the profit. Company is entitled to do the work. Company is entitled to sold out the property. Company is a separate entity. There is no connection of the shareholders with the company. Shareholders are only entitled to get the dividend from the company, but they cannot claim the ownership over the company. If they cannot claim the ownership over the company, it's mean if Salomon having the debentures also, then the debentures must be paid by the company. Even Salomon was the major shareholder, or he was the shareholder in the company. So, principle of separate legal entity was established by this case. And now, in India also, Indian Company Law Act, section 34 of the Company Law Act was also said that the company is a sole legal entity, company is a separate legal entity, and company is itself an owner. Thank you.